Now for Raising the Bar, Greater RVA's premier Law Talk radio show. Call into the show with your stories and questions at 804-454-1366. 804-454-1366.
Good morning. Welcome to Raising the Bar, Richmond's Law Talk radio show. This is Colleen Quinn. I'm an attorney with Locke & Quinn. We are conveniently located at the Willow Lawn Shopping Center, where there's a plethora of good things to eat. So you can come get your beefy burrito at the Chipotle and your chicken salad now at the Chick-fil-A right near our office, along with your legal services. So today we are going to talk about the myths and mysteries of hiring an attorney. What is free? What is not? How does it all work? It can be extremely confusing at times for folks when they do need to hire a lawyer, understanding what is going to cost them and what might be a little more affordable for them. But before we do that, remember that Raising the Bar Law Talk radio show brings an exciting and varied array of legal topics to listeners throughout Central Virginia, and especially in the greater Richmond area, every Wednesday at 9 a.m. The 1-hour show features true life stories and cases, legal tips, and information from experts and specialists. You can view all of the videos from Raising the Bar Law Talk radio show on the Locke & Quinn Facebook page. They're archived there, and we are now also getting them up on the Raising the Bar Law Talk page, which is www.raisingthebarlawtalk.com. We're also getting them posted to YouTube, and also the podcast will be on iTunes. So lots of different ways that you can learn about various areas of the law. In the past, we featured employment law, workers' compensation, personal injury, gestational carriers, adoption, lots of different issues, lots of different areas of the law. So please do feel free to take a look at those pre-recorded programs and learn a little bit more about those areas of the law in which you might be interested. And if you have any questions today, make sure that you call us at 804-454-1366. Again, 804-454-1366. We are here to answer your questions, and today is a very general program talking about all the different ways in which lawyers might be needed by a person over the course of their life. And joining me today is my associate, Kati Kitstein. Good morning, Kati.
Good morning, Colleen.
Great. So we're going to talk about the different times that someone might need an attorney. And it's pretty amazing how the law touches so many different areas of folks' lives. And then also how access to legal services can be a little bit confusing and also rather expensive for folks. The different areas of the law that sometimes folks might need if they're injured on the job. They might have a workers' comp claim. If you buy a house, you might have to do a real estate closing. If you unfortunately are involved in a divorce or custody or child or spouse support matter, you're going to need a family law attorney. If you get a traffic ticket, you might need to have a criminal defense attorney. If it's worse than that, you get a DUI, you definitely need a criminal defense attorney. Some folks run into buying a defective automobile, and that's called lemon law. And some folks will run into some consumer law or some credit fraud issues. Of course, everybody that works is employed, and at some point might need an employment lawyer or have an employment question. If you're injured in an accident, you might need a personal injury lawyer. If you want to set up a small business or LLC, you've got to talk to a corporate lawyer. And if you're unfortunately injured by a medical malpractice or even just a small salon and spa type injury, you might need to talk to a personal injury lawyer. And then, of course, at my firm, we also practice adoption and surrogacy, which is a way of family building. So folks that are looking to family build oftentimes will need an attorney. And so, of course, it can be awfully confusing sometimes as to in which of those cases do you need to pull out your wallet and in which of those cases can you keep your wallet in your pocket and hope that the attorney is going to somehow get paid through the process.
Right. So, Colleen, if I just have a quick legal question, can I just call a law firm and get it answered?
I wish it were that simple, and most folks think it is that simple. The problem is that lawyers are bound by all of these ethical rules, and the rules have gotten more complicated over the last couple of decades. And so it used to be like 20 years ago, somebody could just call a law firm and say, hey, what's the statute of limitations on my personal injury claim? A pretty general question. But now there have been so many cases against lawyers and claims brought that lawyers have gotten a little more cautious about just generally answering any questions out of the blue, because if they don't have all the details and they don't have all the information and they just give a general answer, then that general answer might have a twist to it. There might be an exception to the rule that because they didn't get all the information they didn't know about. But so the best thing to do if you have a general legal question is to Google the issue generally online and just ask the question online. And a lot of law firms have some really good websites and web pages out there that give general information about that particular issue. The Lock and Quinn website, as you know, Katie, because you've worked on a lot of the stuff we've put up there, especially if you go to the employment section, there's a lot of good information on understanding discrimination and harassment claims, on what happens if you're given a severance package. And so the best thing to do is to first just find a reliable resource online to get general information about that particular issue. And of course, the difficulty of if you just call our office, Katie, and you have a general question is that lawyers now have to run conflict checks.
Right.
And you're very familiar with running those conflict checks. And the reason you have to run the conflict check is because you might have represented somebody on the other side and you get yourself in deep doo-doo if you answer a question from somebody that you ought not to be giving an answer to. So by way of example, let's say you called our office and you had an employment question because you had just been fired by your employer. But somebody at our law firm had represented that same employer. Well, we would be in trouble if we then tried to answer your question because that would be a conflict of interest. And sometimes folks don't think about it, but let's say you have a civil rights claim. Somebody has a civil rights claim against a police officer. They feel like they were wrongfully arrested. And we get lots of those calls in our office. And so they call in and they have a civil rights claim and they want to talk to us right away, find out if they have a case. Well, the first thing we have to do is we have to find out who was the police officer, because if we represented that police officer, or one of the other attorneys in the firm represented that police officer in his divorce or his child custody matter, again, we would be in deep doo-doo if we started telling that guy that he had a civil rights claim against one of the clients we had previously represented. So this is a kind of complex issue that a lot of times people, when they call it a law firm, they don't realize that we have to run these conflict checks before we can start to give out any advice, or else we might get ourselves into a state bar ethics complaint situation.
Right. So if I want specific advice, I have to give my name and the names of the people or companies involved just from the get-go.
Yes, that's correct, because we have to know who you are. Did we ever have a case adverse to you for some reason? And we have to know who the other people are that are involved, or the companies that are involved, in case that our law firm had represented, or one of the lawyers had previously represented one of the adverse parties, or one of the folks, as we would say, on the other side of the coin.
So what's that process of running the conflict check? What does that involve?
Well, a lot of firms have, like Lock and Quinn does, we have a PC law system, or you have some sort of a client billing, client accountability system. And so in our PC law system, even if it's a pro bono case or a nonprofit type case, we input every single client into our system so that we can easily run a conflict check with regard to that client, and also generally the adverse party, if there's an adverse party on the other side. Then also we do a backup to that, where we essentially send in an email to everybody in the law firm asking, does anybody have any issue with us taking this particular case? And it could be somebody calls us for a medical malpractice claim against their OBGYN, and it could be that one of our staff uses that OBGYN. So it may not be that we necessarily represented that OBGYN before.
Right.
But you can have different types of conflicts. You can have actual conflicts. You can have just potential conflicts, and then you can have just, I don't want my own law firm to sue my own OBGYN
Right.
conflict. Because I would feel kind of creepy going to see that person. So I'll tell you a quick funny story. My husband had to go for a vasectomy. Yes, and so we go, and of course I'm accompanying him, and you have to have somebody to drive you home. And I'm sitting out in the waiting room, and the doctor comes out, and he says, and this was when I worked for my old law firm, Cantor Arkema, and he says, "You work for that law firm, Cantor Arkema?" And I said, "Well, yes, yes, I do." And he goes, "Well, some son of a bee over there has sued me twice." And I'm like, "Well, that wasn't me." And I'm seeing the doctor get all worked up, and I know he's going to go in there and stip my husband. So this is kind of, so unfortunately, I did not do any medical malpractice at that time in my career, and I quickly moved over and to the side, and I said, I practice the adoption and surrogacy part of the practice, even though I did do personal injury work, but I had never had a case with that doctor, and so I immediately distanced myself from the firm and from anybody at the firm that had sued that doctor before. So that's what we call a practical conflict of interest. And he settled down after that, and then the procedure went fine. But my husband, who was in the back room, told me that when he was asking about me, his wife, and where I worked, et cetera, he immediately turned very red and was agitated and rushed out of the room.
I didn't put him at ease before
That's
the surgery.
right.
So after this conflict check has been run, then can I get advice for free?
It depends. It really depends. If it's a really simple, easy question, like if we get the basic information on a case and it's pretty easy to determine that their statute of limitations has run, then we will readily say, look at, this does not appear to be something we can handle, because based on the information received, it looks like the statute of limitation has run on your case. So there can be some cases in which there might be an easy, simple way of giving advice. Or I'm even directing people. We got a inquiry the other day about sexual harassment. And I said, go watch the video we did on, the myths of employment law claims, which is a good segment on sexual harassment. And then I've had clients too, ask about certain issues with brain injury. And I'll say, go to our brain injury page, and now also go to the video on brain injuries, because that will give you a lot of readily reliable information in that particular area. So it's tough for lawyers to give out just a quick, simple answer, because there are so many complexities of the law that a lot of times you want to get a lot more information about the situation before you give an answer, because you want to make sure you give the right answer. It's when you give the wrong answer that you can get yourself in trouble. And so because of the cases out there against lawyers have gotten a lot more cautious about giving out answers in situations without spending a lot of time with the client and getting a lot more information and making sure the answer is going to be right.
So when I call into a law firm, how do I know if I'm going to have to pay the lawyer or not?
That's a great question, because it really depends on the type of the case. And sometimes it also depends on the type of lawyer, because some more experienced lawyers may not be willing to give a free 15-minute consultation or half-hour consultation, whereas some younger lawyers that are trying to get more business might be willing to give that free consultation. And so There are so many types of cases out there, and we're going to kind of walk through them one by one so that folks have a better understanding of what cases typically might be done on what we call a contingency basis versus what is typically done on an hourly basis. And if you look at hourly rates for lawyers in the Richmond area, you're generally looking at anywhere from about $150 an hour on up to $850 an hour at the larger law firms for more complicated types of cases. So being able to afford a lawyer is indeed a difficult issue. And then we also have a lot of lawyers have gone to flat rates. So that's flat rates are in cases that you pretty much have a good idea of what work is going to be expected. So for example, all of our simple adoption cases, an agency finalization, a relative adoption, a step-parent adoption, we can do those at a flat rate unless a hearing is involved, and then we have to go to an hourly rate to go to the hearing. That's just by way of example on flat rate cases. Some lawyers actually are now setting up LLCs, small corporations for a specific flat rate. A lot of bankruptcy attorneys will do a flat rate to file a Chapter 7 bankruptcy. In our surrogacy cases, we can charge a flat rate for drafting a surrogacy contract, an egg donor agreement, a sperm donor agreement, embryo donor agreement, that sort of thing. And the same thing with a lot of lawyers that do contractual type work. They can do a real estate contract at certain flat rates. A lot of we do estate planning, and estate planning lawyers typically also can do a lot of things at flat rates. And clients really like flat rates because you know what the bill's going to be. Exactly. You know what you're going to get. The hard thing for flat rates with attorneys is if the job goes beyond what they originally envisioned. But that's that's the downside of a flat rate. In some cases, you'll charge a flat rate, and you might not have to do quite as much work as you envisioned, so it all balances out. But a lot of lawyers have started to try to go to flat rates so that they can. The clients can better have a better feel for exactly what they're going to pay. So I think let's kind of talk a little bit further, and as we go through the program, we'll kind of talk a little bit more about what types of cases might lend themselves to a contingency versus which ones are you going to have to pull your wallet out on.
Right. So, okay, let's start there. What does it mean for a lawyer to take a case on a contingency or to get paid on a contingency?
And that's a great mystery as well, that even that term contingency, what does that mean? So it's simple. It basically means that whether the lawyer gets paid is contingent on whether the lawyer is able to get a recovery for you. So that's basically what a contingency fee means. And it only applies to the fee, that is the lawyer's time. And this again is an area that gets confusing. It does not apply to the advance costs. So if a lawyer has to pull money out of their pocket to pay a filing fee or something like that, that is not on a contingency. That is what we call an advanced cost. And so on a contingency fee, that applies just to the time spent, not the money that the attorney might take out of his or her own pocket in order to advance costs on behalf of the client.
Okay.
Yeah.
So if I was in an accident, but I wasn't injured, and I'm more concerned about getting my car properly repaired or getting the full value of my car, is that something I would need to pay a lawyer for, or would there be a contingency fee for that? How would that work?
And that's another question we often get asked. So when lawyers take personal injury cases on a contingency basis, it's because there's an injury and they'll be able to get some recovery for that personal injury. However, in auto cases, there is not going to be a personal injury recovery if it's only a property damage claim. So if it's just simply a property damage claim, then there's no way for that lawyer to get paid because anything that's going to be paid is going to be to pay the value of the car on behalf of the client, or anything that was lost in the car. There might be things that were, lost in the accident, et cetera, that were of value, especially when you're talking about larger trucks and vehicles with equipment on them. But any of that amount is going to go to replace the property. There's no amount there for the attorney to get a slice of, to get a piece of that cut, And so typically when we handle personal injury cases, we will handle any of the property stuff as a courtesy because we're handling the personal injury case. But if it's only a property case, then usually you're going to have to expect to pay a lawyer on an hourly basis just to give you advice as to whether it's a good claim or it's not a good claim or whatever. And sometimes we'll spend 5 minutes and say, hey, did you make sure you checked the Kelly Blue Book? Did you did you go online? Did you check with CarMax? Did you do the other things to make sure it was the right amount? But honestly, if you're going to need to get me involved in negotiating a property claim, I'm going to have to charge for my time on that, because lawyers have employees to pay and mouths to feed.
Lights to keep on.
That's right. And younger lawyers have large law school loans to pay. Yeah.
So what about another type of case? If I, for example, buy a car and it's defective?
So that's what we call the area of lemon law.
Mm-hmm.
And in some areas of the law, the lawyer can actually get a recovery as part of the case. So in a personal injury case, we can't claim attorney fees separately. So usually in a personal injury case, most lawyers will take an auto accident case on what we call a 1/3 or 33 1/3% recovery. Now that can change as you get closer to trial. A lot of lawyers, like we do, once you get into within 90 days of trial, might bump up to 40%. And then like on premises liability cases where somebody's injured on somebody's property, or med mal cases, the lawyer will typically do those at about 40% of a contingency basis. But in other areas of the law, like workers' compensation and lemon law, the lawyer, and also in employment law cases, the lawyer actually can make a separate claim for attorney fees. And so there are those areas of the law where the lawyer might agree and say, you were really sold a fraudulent bag of goods in this defective vehicle. And there's one guy in particular in Virginia, John Gale, that specializes in lemon law, and he's gotten some pretty good attorney fee recoveries on some of his cases. So in those cases, the lawyer might say, we're doing this on a contingency basis, but it's a little bit different because we're capable of actually being able to ask for attorney fees as part of the award in the case.
Right, which helps protect people because then they're not so worried about having to pay a lawyer to bring these claims for.
Yeah, because if you've already been sold a bad vehicle, you're already out of pocket there, and now you got to go shell out money to an attorney to better protect you on having been sold that bad vehicle.
Right.
And so also fair credit reporting cases, the attorney can get attorney fees in those types of cases as well. So in those, another area is Social Security disability cases where the lawyer can get paid out of the Social Security. So I think what we need to do on our website is actually start to make a list of these in addition to all the pro bono and reduced fee services that we've listed there. So we'll be right back after the break. And today we're talking about the myths and mysteries of hiring a lawyer. Call us at 804-454-1366. This is Raising the Bar Law Talk Radio Show, and we'll be right back.
You've been listening to Raising the Bar, Greater Richmond's premier law talk radio show. Call into the show with your stories and questions at 804-454-1366. 804-454-1366.
With SRN News, I'm Rich Thomason in Washington. America's UN diplomat Nikki Haley speaking out boldly about the anti-government protests in Iran. She says the UN should go on the record taking a position on those demonstrations, supporting the anti-government protesters. President Trump says his nuclear button is bigger and more powerful than any that North Korean dictator Kim Jong-un may have. What's more, the president says that his button actually works. Police report freezing rain and ice on bridges in South Georgia as a winter storm revs up along the East Coast. The storm threatens to dump snow and ice on parts of the South that rarely see flurries, much less accumulation. On Wall Street right now, stock futures are higher. Dow futures up about 50 points, and NASDAQ futures ahead by 9 at the opening bell. More details at srnnews.com.
Do you owe more than $10,000 to the IRS? Are you facing potential wage garnishments, levies, or tax liens? With a call to the Attorney's Tax Relief Helpline, you can get the tax help you need through special programs that can reduce your liability by thousands of dollars. Pick up your mobile phone and dial **1234. Yes, that's right. Pick up your mobile phone and dial **1234. Once you've qualified and enrolled, the IRS will stop all collection activities against you. Attorney's Tax Relief has been helping consumers reduce their debt and are trusted and accredited by the Better Business Bureau. Again, on your mobile phone, dial *1234. That's *1234. If you owe the IRS $10,000 or more, call Attorney's Tax Relief now and get free information and to see if you qualify. You can fix this, but don't wait any longer. Pick up your mobile phone and dial *1234. That's *1234.
John Frederick. Governor McCollum. He'll show you some love.
That's why we call you Governor McGenius.
And then
the Lieutenant Governor changed his position on sanctuary cities. First he was for them, then he was not for them, then he was kind of for them, then I don't know what he is. If what you're saying is true, why does he constantly change his position? By the way,
like hot cocoa spilled on your lap. Richmond, Wake Up with J. Fred, weekday morning 6 to 10 on WNTW AM 820 and 97.7 FM.
Before a trip, you program your destination into the GPS. You need the best directions to get where you want to be.
You will arrive at your retirement in 8
It's the same for retirement. You need a voice to guide you. In Richmond, that voice is Isaac Wright. Join him every Saturday at 3 and Sunday at noon on WNTW 820 The Answer. Isaac's experience can help your retirement journey feel like a drive down easy street. Take the first step by tuning in Saturdays at 3 and Sundays at noon for Retire Right with Isaac Wright.
Arriving at your retirement.
Now, back to Raising the Bar. Call into the show with your stories and questions at 804-454-1366. 804-454-1366.
We are back at Raising the Bar, the Law Talk radio show. This is attorney Colleen Quinn of Lock & Quinn, and joining me today is my associate attorney, Kati Kitts-Dean, and we are talking about the myths and mysteries of hiring an attorney, and when do you have to pull out your wallet, and when can you leave your wallet in your pocket? So if you are contemplating needing a lawyer and you have a question for us today, we'll still be on the air until 10 o'clock, and the number is 804-454-1366, and we'll let you know if the type of case you have is one where you're going to have to pull out your pocketbook or not. Mm-hmm. All right.
So jumping back into the different types of cases, we just finished talking about lemon law cases. How about a medical negligence case or a legal negligence case?
Typically, those will be done on contingency. The problem is that having a valid case is really, really hard to find. I mean, you might screen 1 in 50, 1 in 100 cases before a lawyer will find that there's a case that they think is valid enough to take on a contingency basis. So they oftentimes don't have merit, most of the cases that are out there. But most lawyers will at least screen the case for you and let you know that it's not a case that they can take.
Right.
Yeah.
But if a lawyer's getting paid on contingency, they want to make sure that there's that
they're going to get a recovery. Exactly. You want to know you're going to get paid for your time.
Got some skin in the game too, right?
So yeah.
So what if I have an issue with my employer, which I of course do not? But
well, thank goodness. Thank you, Kati. I'm so glad to hear that. So like med-mal, employment cases also are really tough to prove. And as you know, we screen a lot of employment cases, and I would say easily we would only take 1 out of 50 on a contingency basis, and all of the others have to be on an hourly consultation basis. And usually people will meet for an hour and we'll explain to them, what their options are. Is it worthwhile to do a demand letter to the employer, that sort of thing. But again, those cases are really tough to find one that is valid. Yeah.
So what would the lawyer's fee be if there was a valid med mal or employment case?
Usually it's at about 40%. Now, in some cases, it might be 50%. The lawyer might adjust a little bit if the case is not as strong as they would like.
Okay. And you mentioned earlier advance costs. Can you explain a little bit more what advance costs are?
Yeah, so advance costs are when the lawyer actually has to pull money out of their pocket to move the case forward. And so it looks like we've got a caller on the line, and so I'll just explain about advance costs and then take a call from Jack. So when you take on a case, typically you're going to have copying charges and postage charges. And if you're gathering medical records, you've got to pay the providers for the cost of gathering medical records. And then eventually at some point you might have to pay a lawsuit filing fee. And then you might get into depositions where you have to pay court reporters. And then you might get into where you have to actually pay for expert witnesses. And so in a lot of good cases, good personal injury, good med mal cases, good employment cases, the lawyer will go ahead and advance those costs. But under our ethics rules, the lawyer cannot be ultimately responsible for those costs. So if the lawyer loses, they don't get paid their contingency fee. They're out of their time. But under the ethics rules, the Rule 1.8 of our Rules of Professional Conduct say that a lawyer may advance court costs and expenses of litigation provided the client remains ultimately liable for such costs and expenses. So in some cases, the lawyer might say, hey, I'll put in my time for free on contingency, but you're going to need to advance the costs, or we're going to share the advance costs. But that becomes a tricky area because folks don't realize that they ultimately have to be responsible under the ethical rules for the advance costs. So Jack, you're on the line and you've got a question for us. Thank you for calling in.
Yes, ma'am. I appreciate it too. I'm glad I got a chance to hear your radio station, hear your broadcast. I guess without going into a lot of detail, because I know you had mentioned about detail, and then without a lot of rambling about the case.
I'm going to have to run a conflict check on you, Jack.
Yeah, I tell you. But I appreciate people like yourself. I think I can't say enough about that. But my case is I was in a rural area going to pick my wife up from a cookout. And I was in Powhatan, a rural area on back roads, lost. And I was pulled by the state police, pulled by the state police, and received a ticket for not having my license, which was fine because I got a Class A CDL permit with a +5 on my Class A. So I won't worry about that. But I got into an argument with the police, and I ended up with a reckless driving ticket. All right, that's the case.
Ouch.
I got a lawyer.
Yeah.
And the lawyer appears to know exactly what's going on. He's familiar with that courthouse out Powhatan, and he's familiar with the people. But my question to you is that based on the simple fact of what happened, feel like I was unjustly gave the ticket because I got into an argument. In the event that case goes sideways, what is it? Do I have any kind of rebuttal, appeal to if the case doesn't be thrown out of court? Because I'm expecting the case to be thrown out based on the circumstances, but you never know when you go in and what happens.
You just don't know. Yeah.
You really don't know. You know what I mean?
So your best advocate is going to be your lawyer, your criminal defense lawyer that you've hired. I do not do criminal defense law, but I do have the experience of having gotten a reckless driving ticket, so I sympathize with you immensely.
Right.
And the one thing is it doesn't rise to the level of a civil rights type claim because it's not like the police officer beat you up or anything. It's unfortunate, that you got into an argument. But you're going to pretty much have to rely on your criminal defense lawyer to cut the best deal for you. And I don't know, are you in the general district court or are you in the circuit court right now? Do you know?
Well, the case was prolonged, and I'm supposed to go the end of this month to settle this case, which, it's been like 3 months ago.
Yeah.
But I don't know if it's in, what branch of the government who's going to hear the case. I don't know.
Well, there's usually the traffic tickets for reckless driving start in general district court.
Right.
And, when I got my reckless driving ticket in general district court, it was when the Route 288 had just opened, and that was a pretty nice new highway, and I was going downhill.
Right, exactly.
And,
exactly.
And
right.
what's interesting enough is, I went in front of the first general court judge. I did not have a lawyer, and as a lawyer, that was kind of dumb to not have my own lawyer. But, I went in, and the judge said to me, he says, "Now, Miss Quinn, this is reckless driving, and I could take your license away from you." And he said, "But today is your lucky day. Today is your lucky day because
Right.
I'm going to I'm going to suspend your license for 6 months." And I looked at him like, that can't be my lucky day. And then he said, "But it's your lucky day because I'm going to suspend the suspension and just charge me the fine." Yeah.
Right.
But what happens is then your points go up on your insurance. So a bunch of my colleagues ran up because I don't do criminal defense work. And like I said, you need to rely upon your own criminal defense attorney who knows that court and knows that area of the law. But a bunch of my friends ran up and they said, "You need to go to driving school and you need to appeal this to circuit court." Well, the circuit court judge, he basically found out I went to driving school, found out I had just bought a new car. It went faster than my old car, which would fall apart. And
Right.
the judge on the circuit court level reduced it to driving with defective equipment. So that just kind of illustrates the crazy different outcomes you can get. But I would definitely count on your attorney to give you the best advice because that attorney works in that court system, knows those judges, and is going to know the best deal to cut for you.
And see, that's the part that I just don't want no deal because I just totally feel like I was innocent. You know what I mean? And being that, the respect level was disrespect on his part, my part, of all parties involved, which was myself and himself. He had the upper hand in being able to write that ticket the way that he wanted to write it and do what he wanted to do. And I was pretty much at his mercy. But if I would have known what I know now, everything is a learning experience. Sometimes
it is indeed.
It costs, sometimes it costs, sometimes it don't cost.
That's right.
But I definitely learned something when to get pulled by the police, But based on that previous getting pulled, that class A +5, I just knew that he was going to respect that. You know what I mean? But he had no respect for my position of being a professional, so-called professional driver, a commercial driver, driving heavy equipment, moving big tractor and trailers or whatever the case may be, and ended up with a ticket because of a disagreement.
That's really tough sometimes, but, police officers, they do have the upper hand, and that's the way our society works. And so,
right.
I would just, again, Jack, say that you've just got to kind of follow the advice of your attorney and count on him for that. And the good thing is that you are smart enough to have gotten an attorney, unlike when I first went in. So well done in that regard. And
Yes,
I really appreciate you calling into the show today. And I wish you the best of luck. I do hope your case gets thrown out. Thank you.
And like I say, I don't have no appeal at all if it doesn't go the way I wanted to go.
I don't know because I don't know which court you're in. If you're in general district court, you'll have an automatic right of appeal to circuit court. But talk to your attorney about that. And thank you so much for calling into the show. All right. Great call from Jack. And we're going to talk a little bit more about those types of cases where the attorney might get paid out of some sort of recovery.
Right. So is there ever a case where a lawyer can get an award by the court in certain cases?
Yes, actually, we talked about getting attorney fees in workers' comp cases and other cases, but another one that I failed to mention was in some family law, spouse support and child support type cases. The judge has the ability to make an award of attorney fees, and this is really, really important when you have one spouse that's been the working spouse and holds all the money, and the other spouse doesn't work, or especially is at home with the kids. And so it's important to have that sort of award out there so that the disadvantaged spouse can get an attorney.
Yeah.
Now, sometimes that might need to be a younger attorney, who's willing to take that case without getting paid until the end of the case via an attorney fee award. Whereas your more experienced attorneys can afford to turn down that case and say, no, I'm only going to take the case on the paying basis. So the other way that sometimes attorneys can get paid is with an award of sanctions. And so in some family law cases, the court can award like back support. They can award attorney fees, but sometimes they can award attorney fees as part of a combination of sanctions. So if you have a case where one side is just trying to drive the other side into the ground, then the court has the discretion to make a sanctions type of award. But again, it's hard for lawyers to take on a lot of cases where they know they're not going to get paid until the end because, we've got to pay our staff and keep the lights on and all that too.
Exactly. So if I can't afford an attorney, I don't have the type of case that's going to qualify me for, a contingency or something like that. What do I do if I need legal help and I just can't afford it?
Right. So we have compiled on the Raising the Bar Law Talk radio show website. So that's at www.raisingthebarlawtalk.com. An excellent list of all the pro bono and legal aid resources and reduced aid resources that are out there. I was actually amazed at some of the resources that are out there. Now, a lot of folks are familiar with legal aid and Virginia Poverty Law Center, and you have to really be at the poverty line or below to qualify. But there are a lot of other statewide resources out there. For example, there's the Community Tax Project for low-wage families that have tax problems. You worked at the Disability Law
They were
Center.
on the radio show too.
Yes, and they did the radio show, and so there's a whole program on what the Disability Law Center of Virginia does. There's the Drive to Work program, which assists qualified low-income and previously incarcerated persons to restore their driving privileges. There's the Hogar Immigrant Service program that helps provide immigrant legal advice at reduced rates. Legal Information Network for Cancer, victims or survivors or folks that have just been recently diagnosed. The Women's Bar puts out a domestic relations pamphlet, which is an excellent resource for providing a lot of advice on family law, domestic abuse, protective orders. There is the Virginia Bar Association Veterans Issues Task Force, which has sprung up. So veterans now have more resources. VirginiaFreeLegalAnswers.org is a great website where low and modest income folks can pose a civil law question and get a free email answer. So that's one of those places where you can, rather than Googling it online, kind of send in and get a general answer. There's also a Virginia Judicial System self-help website, which provides similar type advice. And of course, if you're willing to take on generally a younger lawyer, but still get low-cost services, the Virginia Lawyer Referral Service provides a 35-minute free phone consultation or in-person consultation with a whole network of lawyers throughout Virginia. Actually, when I first got started, that was one of the things I did because I wanted to build my practice. And oftentimes that 30 to 35-minute free consult would turn into additional work that was needed. And then you would have already, met the client learned that they liked you, and so you had that rapport, et cetera. And so if you go on our website, you'll see that there are the additional resources of the Virginia Military and Veteran Legal Resource Guide. And then, of course, there are the Virginia Poverty Law Center, Virginia State Bar Pro Bono Access to Legal Services, the Virginia Law Help to Go, and Virginia Legal Aid. And those are all statewide services. And then we've also listed out the services in particular areas, such as in Northern Virginia, Central Virginia, Eastern Virginia, and then also in Western Virginia. So that compilation of different resources is something I've wanted to do for quite some time now, because we do get a lot of folks call into our law firm, and we just, aren't able to take that case and want to be able to put them in good hands, or tell them where they might be able to go and get either free or lower cost legal services.
Right. So what areas of the law typically are not free?
So the areas that are typically not free are going to be those areas where, for example, you want to set up a corporation or an LLC, or you're doing a real estate closing, or you've got, we mentioned in most employment cases, you're going to have to pay for somebody. Intellectual property cases, if you want to copyright or you want to trademark something. The areas of the law that tend to be more business oriented, doing a merger or acquisition, securities law, purchasing commercial property, environmental compliance. So in those areas that tend to be more corporate or business based, you're going to pretty much have to plan on paying an attorney. One area that is kind of a conundrum is the criminal area, because you hear whenever when anyone's read their Miranda rights,
every cop show ever,
and if you can't afford an attorney, one will be appointed for you. So there are certain times when if it's a criminal case and you can't afford the attorney, then the court will appoint one. But in many, many criminal cases, the person can afford an attorney. And so again, that would be an area where somebody would have to expect to pay their attorney on an hourly basis unless they qualified for the court-appointed one.
So are there any other non-criminal cases where someone might get a court-appointed attorney for free?
Yes, that's a great question too. So in cases where somebody is losing their children, a case where Department of Social Services has removed the child from the home for abuse, neglect, or something similar, abandonment, then that is what we call an involuntary termination case. And typically the court will appoint an attorney in those cases, unless they decide that they have the income and ability to hire their own private attorney. But so usually the court looks at, do you have a fundamental constitutional right? Like, are you going to lose your right to freedom because of a criminal claim? Are you going to lose your right to parent, lose your right to your child, because the child's been taken from you? And then if you don't have the ability to hire your own attorney, then the court looks and says, those are cases where we're going to go ahead and appoint an attorney for you. The other cases also are where somebody needs a guardian. So if it's a case that involves a child under age of 18, oftentimes the court will appoint a guardian. If it's somebody that's incompetent or has mental or emotional deficiencies, they're in and out of mental institutions, the court might appoint a guardian for them in those cases as well. And
that would be an attorney that the court.
Right. And so, the guardian is a guardian ad litem or a guardian, and that would be a licensed attorney that's appointed by the court. And then what's interesting too is that, because you know this from the cases we've handled, is that if you bring a case against an incarcerated felon, for example, you're doing a step-parent adoption against one, or you're proceeding against them on a personal injury case for whatever reason. They won't have any money, but it might be that there's some sort of insurance that you're going after. Then typically that is considered under a disability, and the court has to appoint a guardian ad litem for an incarcerated felon if there's proceedings being brought against them.
Okay, but not if they're the one bringing the proceedings.
But not if they're the one, exactly. Yeah. No, you don't get a free attorney that way.
Okay. So if I do need a lawyer and we figured out how the lawyer is going to be paid, am I going to have to put something in writing or sign an agreement saying how they're going to be paid?
Typically, yes. And that's called a fee agreement or a retainer agreement. And as I mentioned earlier on in the show, a lot of lawyers are getting especially skittish, about getting sued by their own clients. In one case, I actually had the client attempt to fire their attorney and settle out. I was on the other side of the case, but fire their attorney and settle out and cut the attorney out of the picture.
Right.
So attorneys have gotten a little bit more skittish about that. And then also our legal malpractice carriers have started to require us to put things in our retainer agreements, including how long we're going to keep your file and when you can terminate the representation or when we can terminate the representation. And if there's, for representing a married couple, we have to put in conflict of interest information. So the retainer agreements have gotten a lot more extensive, but you typically will be required to sign some sort of agreement with your attorney if you hire one.
Okay. So beyond this retainer agreement, how are lawyers supposed to communicate with their clients?
And that's a great question, because a lot of lawyers get in trouble because they don't do a good job of communicating. So we always ask our client, how do you want to communicate when they come in? Is it by text or by email or by phone? And everything that goes out of our office, we copy the client on. So I always say, we're not sitting around eating bonbons. We're actually working on your case. And so you're going to get a copy of everything that goes out. And keeping in constant communication with the client is just critical. And it's something that results in a lot of bar complaints, because it's one of the things that lawyers need to do better across the land.
Mm-hmm.
Yeah.
Well, so how about the flip side of that? Do you ever have problems with clients not responding to you?
Unfortunately, yes. We've actually had to send, folks out to our client's house, send a process server out to make sure that, they're getting our correspondence. In some cases, you actually lose the client. They move and they don't let you know where they are. So we do have those situations where our clients suddenly go in some deep big hole somewhere and we don't know where they are, and we keep sending them letters and then certified letters, and then eventually have to send somebody out to the house, or we have to contact a relative or somebody and find out what the heck is going on. Exactly. So there is the flip side of that too.
And so how do lawyers typically bill? And this might be a reason why you want to stay in touch with your client.
Right. Yeah, because you want to get paid.
Right.
So usually if it's like most paying cases, the lawyer will get a retainer up front. So they're going to get an amount up front. If it's the flat fee, they're going to get the flat fee up front, or they're going to get half of the flat fee, do half the work, and then get the rest of the flat fee up front. And so if it's an hourly type case or a flat fee type case, or sometimes there might be a hourly with the contingent piece type case, the lawyer's going to get their money up front, or they're going to get a good chunk of their money up front, and then they're going to send a monthly bill out showing what work has been done against that amount. If it's on a contingency basis, it could be very different, because most lawyers will want to show their clients at least what the advance costs are that they've been paying on their behalf. So typically most good lawyers will send out the bill on a monthly basis on the contingency cases too. Not with the time, but just basically saying these are the advance costs that you're ultimately responsible for, and we just wanted you to know. And then some lawyers will actually have a deal with the client that we're not going to advance more than $500 or $1,000 in advance costs without sitting down and talking about it. And that's only fair to the client, because they're ultimately responsible.
Right. Don't want to blindside them.
Right. I mean, they hope you get paid out of the recovery eventually, but
right.
But if you don't, then ultimately under the ethical rules, it's their responsibility.
Right. So I guess before we wrap up, this is a question I know we get a lot. Who owns a client file?
Yeah. And that's a great question as we close out our show today. So typically all original documents are owned by the client. And you do have a duty to provide the client with copies of anything that was done, any pleadings, any critical work, any important documents that were done. You don't have the duty to provide them with any internal memos or anything like that. You do need to provide them with their bill and any billing, and of course you want to do that. And it gets a little bit more complex, but that's kind of the general rule on the client files. So we really appreciate you joining us today for the Raising the Bar Law Talk radio show. Please join us again next week on Wednesday at 9 a.m. as we address another scintillating legal topic. Thanks and have a great day.
Where's the best news and talk? AM 820, WNTW Chester is the answer.
News this hour from townhall.com. I'm Rich Thomason. The harsh cold across a large part of the country is blamed for at least a dozen deaths. And now there's a powerful storm revving up off the southeast coast. Could bring ice and snow to North Florida, coastal Georgia, and the Carolinas before moving north to
Eastern Virginia, Norfolk area, Hampton Roads, but also the Delmarva and areas along the Atlantic coast. That would include Ocean City. That would include areas like around Salisbury. That's where we could be looking at significant snow, certainly 4 to 8 or even more inches of snow out in that area.
National Weather Service meteorologist Brian Hurley. President Trump reminding North Korea's dictator that he also has a nuclear button.
The president's tweet yesterday came after Kim Jong-un said in his New Year's address that he has a nuclear button on his desk. The president responded he too has a nuclear button. Quote, but it is a much bigger and more powerful one than his, and my button works. Thing is, the president does not really have a nuclear button. The nuclear strike process is a lot more complex, involving codes unique to him and then transmitting launch orders. Sagar Meghani at the White House.
The two Koreas have reopened a hotline between them that North Korea severed a couple of years ago.
The South Korean government has welcomed the development, calling it a move towards direct and frequent dialogue between the divided Koreas. It is the latest sign that high-level talks about the potential of Pyongyang sending a delegation to the Winter Olympics could take place.
That's a BBC's Sophie Long in Seoul. A first-of-its-kind genetic treatment for blind